Let's talk about the politics and sort of in the historical perspective of things of all of this with Dr. William Rosenberg, professor of political science at Drexel University, the co-author of News Verdicts, Debates in the Presidential Campaigns, among other things, tweeting at DRB Rosenberg. Bill, welcome back. Thanks for being here today.
Good morning.
This is a reversal, it seems to me, of what we saw in 2016, and in some ways it's a little bit different because of the distance between the nomination and the possible confirmation. As opposed to 8 months, we now have just weeks. In addition to that, President Obama wasn't running for re-election. But that said, it's kind of the same thing we heard in 2016, right? Only the sides have swapped.
Well, we're really facing what I would suggest right now is hardball politics. Mitch McConnell has made the cornerstone of his political career to get the judicial branch to be much more conservative. He's nominated he's processed basically about 300 federal judges and now 2 Supreme Court judges, and this is one more example of how he's trying to keep another jewel in his goodie box by getting another Supreme Court justice. For those of you that are really upset or nervous about what's going on now, I would suggest a image of what if Donald Trump wins in November, the Senate stays Republican, there may be 2 more very conservative justices put on the Supreme Court just because of deaths or retirements. So this is really a very, very critical point or a tipping point in terms of what goes on. The president has the right to nominate people at any time for the Supreme Court if a vacancy occurs, and the Senate has the right to advice and consent. But it's going to be interesting to watch how this plays out.
Is it a right or an obligation? I mean, I know it's getting into constitutional law. It says the president shall, and the Senate will advise and consent. So, and I go back to the Ruth Bader Ginsburg quote in that 2016 New York Times interview with Adam Liptak, where she said the president doesn't stop being president before the election.
Well, I would say that it's actually interesting. I wrote a paper a few years ago about this subject. The president does have the right. It's stated in Article 2 of the Constitution. And if not for the president, who would nominate people to the Supreme Court? So it's a position that he holds and that he must, in effect, act on. The advice and consent issue, though, is a little bit of a outlier in the sense that the Senate has to be consulted. But there's no real requirement that even the advice and consent has to be, at least the advice part has to be followed. At the end of the day, it's a vote. It's done by the Senate. Only senators can vote for it. And basically the difference, as you're sort of alluding to, is that policy about advice and consent has changed over time. Until the 1970s, it required a 2/3 majority of the United States Senate to confirm a nominee to the Supreme Court. And then it dropped down to 60 votes. So from 2/3, like 66 or 67 votes, down to 60. And now with the nuclear option that got started largely because of a decision by Harry Reid, because there was a blockage of appointments being able to be made on the federal judiciary, he made a what I would say is a dramatically dangerous decision in which he lowered the number to 50% plus 1 vote. And that's what basically sunk Merrick Garland's nomination, because Mitch McConnell took the Reid rule, essentially, and expanded it to include the Supreme Court, which it was not the original intent. But that's why we now have a couple of people sitting on the Supreme Court who never would have been on the court, including Neil Gorsuch and Brett Kavanaugh, because their vote totals were not anywhere near 60.
Bill Rosenberg, Dr. William Rosenberg, professor of political science at Drexel University, is with us. You made the point before that if Donald Trump is reelected and the Senate remains in Republican hands, that he could make 2, maybe even 3 more appointments to the United States Supreme Court in a second term. There are a lot of things that could happen. If Joe Biden, for example, were to be elected and the Senate were to go to Democrats, he could make 4 appointments. I mean, you never know how it's going to shake out. I mean, Supreme Court justices could retire. They could do a lot of different things. They could pass away. It's not like we're asking for that to happen, but The point is that if Democrats are now talking about if Republicans move forward on this, they're going to retaliate and they might add members of the Supreme Court, et cetera. It just seems to me that cannot be a good thing for our politics if it's politics by retaliation. And as Isaac DeVere is writing in The Atlantic, Mitch McConnell saying the golden rule is the power goes to whoever has the gold. And in this case, Republicans do, Democrats might. And then it changes or is that the way it's always been?
Well, just as a response to the first part of your comment, I would say that there are some people that are likely, unless something really unusual happens, to not be leaving the court in any time soon. They're much younger than others, so people like Alito, Sotomayor, and Elena Kagan are much younger than others like Stephen Breyer or Clarence Thomas. So I think we have to recognize, just as a general manager on a football team looks at who he has playing for him, that some of your players are rookies, some of them are in mid-career, and some of them are aging. So I think that's part of the calculus that goes on. But in terms of your point about court packing, probably the focus of much of that discussion goes back to FDR, who was constantly frustrated by a Supreme Court that was not allowing his New Deal legislation to be considered constitutional. So he put into place a policy that he wanted adopted that was going to basically appoint additional judges to the Supreme Court, tied to how old the person was if they refused to retire by the time they were 70. And he thought that the court maximum could get up to 15 judges. At the end of the day, though, the Congress refused to go along with the court packing. And if you think about it as well, you have these 9 people in these big chairs in a big building in Washington called the Supreme Court. Would you have 15 judges hearing all cases, or would it be more like some of the lower courts where you would have a panel of judges out of the 15 that would hear the case? Then the decision would be who of those 15 would be the ones who heard a specific case. And this is becoming very troublesome, not just in terms of the numbers, but just in terms of the cases that the court's going to be hearing in the very near future. Think about the election cases that are going to pop up, like in 2000 when there was a question about Bush v. Gore, or think about the Affordable Care Act. These are 2 major pieces of court cases that are going to come before the court in the very immediate future, and then it becomes sort of almost like a parlor game of who's going to vote which way. And in many ways, we're probably going to see more of the action of Chief Justice John Roberts, maybe siding a little bit more towards the center with some of the more liberal judges, but we'll have to wait and see.
The last part of this is just, and I'm offering this, is that it seems to me the politics of this is such that it points to the inability of a Congress to do things, and therefore they are designing their arguments hoping that they will get support from the courts. In other words, they kind of come up with something figuring we'll let the court decide this, and we know we can sort of figure out how it's going to go based on who we have on the court. Not that it always works out that way, but it just seems to me that they're abrogating some of their own responsibility to find things that are constitutional and come up with things by virtue of compromise, and they're hoping that the courts sort it all out. Well,
this was the dream of the founding fathers, to have a true separation of power, to let one branch check the power of other branches of government. But as it's worked out, it really hasn't been the case. Supreme Court justices have surrendered their seats with the hope of keeping the seat within the same ideological spectrum. But it's kind of a tough thing to time, and things happen during confirmation hearings that throw this off. But one of the things that I would really suggest is that, this is another example of how the succession from one justice to another is somewhat problematic. If you think about Thurgood Marshall, black civil rights leader, a true liberal lion, what happened with him when he left the court, he was replaced by Clarence Thomas, who was almost the exact opposite. And what we're seeing right now is very likely to be Ginsburg being replaced by a very conservative person. When you look at the list that has been developed by the Trump administration, using groups like the Federalist Society. They're only going to put a very conservative, young, and it sounds like female on the Supreme Court, who was very likely to have a legacy of almost 35 years, long after Donald Trump is roaming the political fields of our country.
Dr. William Rosenberg, Bill, thanks as always.
Have a nice day. Take care.
You too. Dr. William Rosenberg, professor of political science at Drexel University, joining us for discussion on the Supreme Court nomination and confirmation process, such as it is these days, tweeting at DRB Rosenberg, Rosenberg.